Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources. SEER is a member organization whose mission is to foster the success of a diverse community of environmental, energy, and resources lawyers, advisors, law students, and decision makers, and provide a premier forum for the exchange of ideas and information.
This is the Look Back at 50 Years of EPA, a limited podcast series where we interview practitioners in the development of environmental law and EPA. My name is Phillip Dupré, and I'm a member of the Leadership Development Program of SEER. In this podcast, I'll be talking with Quentin Pair. Quentin spent 35 years at the Department of Justice's Environment and Natural Resources Division, where he primarily prosecuted Superfund cases on behalf of EPA. Quentin also did considerable work on environmental justice issues at both DOJ and EPA. I hope you enjoy our conversation, which we've broken up into 2 episodes due to its length. In this first episode, we discuss Quentin's background and his experience prosecuting some of the first Superfund cases. We also discuss his introduction to environmental justice. In the second part, we continue our conversation about environmental justice, and he gives his thoughts on the challenges facing EPA and what the agency might consider moving forward.
Sure. Quentin Pair, born and raised in Westchester, New York, little place called Mount Vernon. Went to undergraduate school at Howard University. D.C. is my family's hometown, my father's people. I left Howard and matriculated at American University. And from there, I went to BU Law, graduated in 71, and I didn't have any idea I was going to law school, much less getting involved in environmental law. In fact, when I was my last year, I thought I was going to Wall Street. And I'd worked for IBM my first summer in law school for the general counsel, and the second summer for the new first billion-dollar corporation, PepsiCo, for the general counsel. And I thought I had a job going to Paris to open the first international law office. By the time we got to January, the general counsel had left PepsiCo for a vice presidency at Revlon. And so I was going to be pushing an ice cream truck with a law degree in my back pocket. And I had a wife and kid. And my criminal law professor called me in and asked if I'd be interested in going to Europe to do court martials. The answer was no, I wasn't interested because I wasn't playing around with military law or criminals. I wanted to go to Wall Street and make some money. But I didn't have a job. And I was also interested because criminal law was not my best course. And I told him, I said, I didn't attend that many of your classes. He said, I know, Mr. Pair. He said, every time I'm out lecturing, you're there being a pain in the butt asking questions, and I think you'll make a good trial attorney. I said, yeah, okay. Went to Europe to a firm called, it was F. Lee Bailey and Melvin Belli. I don't know if you're old enough to know who they were. F. Lee Bailey was the top criminal defense lawyer in the country, and Melvin Belli was one of, if not in fact, the top civil lawyer. In fact, they called him the Prince of Torts. And they had hooked up with this guy, with Edward Bellin in Germany, who was one of the top names in military law. He was a civilian. He had a civilian practice. So I went over there to stay for a year, wound up staying 5, walked out of law school into simple cases like robbery, first-degree murder. Did this for about 5 years, was a senior trial attorney there. After 5 years, came back to D.C., and that was in private practice with a small firm doing basically the same thing. Criminal practice, specialized in criminal practice in the D.C. Superior Court and also in the Federal District Court. And then one day, a judge of mine called me in and asked me to interview at Department of Justice for this new section that they were starting on hazardous waste. No background in civil practice. I went for an interview. They thanked me very much for coming in and told me they had already given away the last position. I think he was a friend of the judge's, and he was just doing that as a favor to her. But 2 weeks after that, I got a call back. My plan was to go work for the feds for about 2 years, just enough time to make sure I paid off my daughter's tuition at Tufts. schools are the biggest bandits. They want their money up front. And I was having too much fun enjoying defending my criminal defendants. And one day I walked into my office at DOJ and found a 25-year certificate sitting in my chair. They had turned me into a bureaucrat, and I didn't even know it. And I wound up having a 35-year career at DOJ. And I was a senior trial attorney in environmental enforcement section. Super fun was my main line of cases that I was involved in. But I became involved about halfway through, a little bit more than halfway through, in environmental justice. I spent a good 20 years from about 1998 till 2015 when I left the department.
So taking a step back, I know you graduated law school in 1971, which would have been 1 year after EPA had been created, or maybe even, I guess, 6 months, depending on the dates. When you were in law school, did you have any concept of environmental law?
No, none at all, and had no real interest. I mean, I was in corporations and contracts, and no, I didn't have any idea about environmental law. We didn't have it offered at the school, I don't think, at that time.
Yeah. Well, obviously, it would have been very new. The Clean Air Act was passed in 1970, Clean Water Act 1972. TSCA and RCRA 1976, and then Superfund in 1980. So it really, in that decade of the 70s, it just proliferated. And when you were in private practice as a criminal defense attorney, what was your concept of environmental law or what that meant?
Absolutely none. Zero. I mean, when I came out of law school, I wanted a job, as I said, and I wound up doing court-martial work in Europe for 5 years using the Uniform Code of Military Justice. And basically, we use the same rules, unified rules on criminal law, just like in the United States in the civilian courts. Really didn't have any interest in it. I was more interested in the problems of diversity in the military. A large amount of my practice was representing black GIs that seemed to be getting into trouble more than anybody else. And I did that for 5 years and continued that vein when I came back to DC. And when I got invited to interview with DOJ, I told them up front I had no civil background whatsoever. But the guy who hired me, Tony Roisman, he was the first section chief, told me basically, there were 20 lawyers that started the section, 18 or 20, and I had more trial experience than all of them put together. He wanted someone who could walk into the courtroom and stand there and go toe-to-toe with the prosecutor or opposing counsel and the judges, and at least knew where the bathrooms were in the courtroom, in courthouse. And that's why he took me in. So I had to OGT all of my knowledge about civil practice, starting at the department, which was quite a sojourn.
So now when you were brought in, this was right after CERCLA was passed, were you brought in specifically to work on CERCLA and RCRA type cases?
Well, that's what this section was specifically created at the Department of Justice to take on CERCLA cases and also RCRA, since they're related. We eventually melded into, there was already an environmental enforcement section, but that handled water cases and air cases. But eventually we melded those to the hazardous waste section into the environmental enforcement section. Okay. And therefore, we got the other media as well. I was brought in to join the team to do Superfund cases, whatever that was going to be, because we didn't know. Yeah. I mean, there was, I remember the first of the something 50, some little magic name 50, first 50 cases of Superfund. We were making up procedure and process as we went along. I wound up being the lead counsel on a case which was referred to as the Bluff Road. It was in South Carolina. It wound up going, it was against two small landowners who were doing a recycling business, and they had 2 or 3 sites around in the area. And we sued the landowners. Eventually, we bought in 30 or 40 generators. It wound up going to the Supreme Court and came under Monsanto versus the U.S., and that was the first Superfund trial. A lot of things started breaking in those first 5 years.
What were some of the hurdles you had to overcome in that first Superfund trial, either with opposing counsel or the court system, just litigating under this very new and arguably very broad statute?
We were assigned to the Chief Justice for the South District of the South Carolina, and it was the beginning of the Reagan administration. And basically, we was a joint complaint with the state of South Carolina, DHEC, the Department of Environmental Protection. So I went to the U.S. Attorney, Assistant U.S. Attorney, welcomed us into the courthouse. She said, "Listen, I'll take you in, I'll introduce you to the judge, but I got other things to do."
Yeah.
I don't know anything about the so-called environmental law business. So you'll take it from here. You know, justice runs with these things. I said, "Fine." Walked into the court. He knew her. Well, Ms. Jones or whatever, I can't remember her name. "Nice to see you again today." And she said, "Thank you, Judge. I'd like to introduce you to Mr. Pair from Main Justice, who will be handling the case." And she was packing up her stuff, ready to go. And he said, "Well, I have a few questions." He says, "Why do I have this case? I thought the new administration was going to let the states take care of its own problems." And I had stood up, I sat right back down, and she tried to explain the complexities. And he says, "Well, I just don't know." And every time I would stand up, he would not recognize me. He didn't even want to talk to anybody from Washington. He was focusing. He didn't even acknowledge my presence in the courtroom. My co-counsel was a young attorney from DHEC from South Carolina, who didn't have any experience. And I pinched him under the table and said, "You better get your ass up here." Judge, the importance of this case to you and the state. And he got up and said, "Well, look, Judge, we've been trying to get a hold on these landfills around here, and these toxic substances are poisoning the groundwater and all. And these defendants keep moving their product around from one site to another, and we just can't get hold of them." I just said, "Do I understand that the gentleman representing the fine state of South Carolina is asking this court for sugar? What'd you say this fellow from DC's name was?" And that's how we got introduced, because he lived in a nearby town, and when he heard about the contaminated groundwater, the judge took a personal interest. And from that day forward, we never had a bad ruling from that judge. I mean, I have 30, 40 minutes of war stories just with that judge in that case, which I don't want to get into, which is too long, but he was very conservative. He was and if I may digress just for a moment and tell you this is why you go to law school.
Please do.
So this was the first case to be cited on summary judgment, and it was a big deal in the industry. The industry went out and hired an expert just for this hearing. And you had Monsanto, you had Allied, you had big names that we had to. And on the day of the hearing, all of these vice presidents from these companies showed up. I mean, the gallery was packed with industry people. So I sat there to table, and it was just opposing counsel, and he had an assistant. He had a local attorney. And then there was this hired gun that they brought in. The local attorney was actually it was a partner in the firm that the former governor was principal partner. And the judge walked in the courtroom, and all my EPA lined up at the table. And this was, we all felt the pressure, because you didn't want to be the first lawyer to lose a Superfund case. And the judge walked in and said, "I'm prepared to rule for the government in this matter," and told us, "Everybody sit down." Well, that didn't go over well with him. So the local counsel got up and, "We need to be heard on this, Your Honor." And he went on and on about it. And we had a decision from a judge in Pennsylvania on U.S. v. Ward, which was another case that was ongoing. It was on the question of strict liability. And he ranted and raved, and he said, I'd hate to think that my judge was going to be hoodwinked by some judge from way up there north. And he said, well, I think you're referring to Judge Jones, who's coming down here next week to play golf with me, and I'll be sure to let him know your concerns. And with that, the judge was gracious enough to let the governor's law firm attorney, the Silver Fox, we call him, who was real sharp and real good, let him have his say and thank them. And he said, I'm ruling for the government, and walked out the courtroom. That was the beginning of my real beginning in career in environment in the Superfund. And we had a number. I'm very proud of that case because it settled most of the questions on liability, which is still extant to this day. It went up to the Supreme Court on all possible issues, constitutional issues, the court found for the government. And as I said, there are a lot of changes in Superfund these days, but the basic liability issues, particularly on joint and several liability and strict liability, still stand.
Yeah. How much, obviously you were new to environmental practice then, but how much of, that concept of joint and several strict liability for environmental harm was just a sort of a hurdle to get over both the private bar, corporate interests, judges? I mean, it's a tough statute.
Well, it is. And the private bar fought tooth and nail, and they made a very heavy investment in legal resources to fight everything. It was like no quarter given. The courts, though, and the law seem to recognize it now. I'll tell you, I had a problem coming into it because of my criminal law background. That when you had, someone, not ex parte.
Ex post facto?
Thank you. Don't get old. And we were going forward with the cases where these defendants were accused of incidents or events that happened 20, 30, 40 years ago. And we want to hold them responsible today. I was one of the few attorneys in the section who just said, wait a minute. Okay, I think we're being a little too aggressive, and had quite an internal battle. The long and short of it is I lost the argument internally. We went forth with the argument, and the courts had no problem with imposing civil liabilities for ex post facto events where you could show that they were, in fact, directly responsible. And so, again, in terms of the law, it was not that much of a problem, but the private bar did fight quite hard on all of those points.
So how did those first cases come to DOJ from EPA? And was there any back and forth about, which cases should be brought first, which were losers y'all didn't want to touch, or how did that process go about?
There was a lot of back and forth between EPA and DOJ. We were all feeling our way into this new area in terms of what the law was going to be. How did we create the arguments, choose the cases? Particularly, I didn't have that much involvement in the beginning. That was all at a pay grade where, I was at the Assistant Attorney General's level. All of the cases, enforcement cases that are handled in the Environment Division, or specifically the Environmental Enforcement section had to be referred from EPA to the Assistant Attorney General for a request to prosecute. But it was then up to the AAG to decide whether to accept the referral or not. And once it was in DOJ's hands, then all litigating questions resided in the domain of DOJ. And we had to keep the client informed, etc. And it was ultimately EPA's decision on what they wanted to go forward. But once they referred it to DOJ, all issues of litigation were decided by DOJ. Now, as a practical matter, all of our teams were composed of DOJ and EPA lawyers. Nominally, U.S. attorneys were involved. All cases that were brought to trial had to be signed off on by the U.S. attorney in whatever jurisdiction. But very rarely did they become involved with these because it was just too technical for them to handle.
Mm-hmm.
So there was, in fact, a blending of at the trial level. I had EPA attorneys and technical support from EPA. And then I had, junior attorneys from the DOJ on the team. We had discussions at our senior supervisors, both DOJ and EPA supervisors, it would go pretty far up the ladder depending upon the importance of the case and the issue at hand. And so there was really a blend managerial decision, because just because DOJ had the final say-so on litigation matters, they weren't going to piss off the client unnecessarily. It was, for the most part, there were always disagreements, and there were always sore points, but they made the system work.
And I am curious, were there any issues in the early work under CERCLA that sort of tended to come up, more of big picture issues of when maybe DOJ saw something one way, EPA saw it another way, as compared to just sort of the run-of-the-mill disagreements on cases that sometimes happen?
Well, I'll give you a good lawyer's answers. It depends. For the most part, it worked. The system worked. But yes, there were definitely different differences as agreement, and there were clear recognitions, which was issues that were in the providence of the client. And then, particularly in consent decrees, that was DOJ's province specifically, signing off on them. And you probably know that from your work. It would depend on issues. There were definite disagreements, but they were worked out. Meaning sometimes the agency got its way. Sometimes, there were times when I know that we made recommendations to EPA that they should look at a particular area of concern, particularly when I got involved in environmental justice. I would have people, I was the environmental justice coordinator for the department, sat on the Federal Interagency Working Group on Environmental Justice. We had, one of the things we did under the Interagency Working Agreement was develop a directory for contacts in the federal government. There was environmental justice coordinators throughout the federal family, so that if Joe Sixpack, called up transportation because they were doing something, I live in a low-income community and they're taking advantage, blah, blah, blah. The person there might not know what to do, but he would give them my number. Thank you very much. And what we would do is we would try to direct these complaints or concerns to the appropriate officers within EPA. And we might even have an opinion. If you made the mistake of asking me for my opinion, I would give it to you. And sometimes EPA would, appreciate it, and sometimes they wouldn't. And you get into things like funding issues, resource issues, what's going to give you the biggest bang for your buck. So that's kind of a complicated issue right there.
So turning to environmental justice, as a concept, when did you first hear of the words environmental justice? And did you have a notion of what that meant, even if it wasn't in that terminology beforehand?
Once again, clueless. I was sitting at my desk just bemoaning the fact that I'd spent about 20 years by that time in these big, complicated, expensive litigations, suing the big names in the industry. And it was just taxing. And so I got, about 20, almost 30 years of practice under my belt by that time. And I looked around and seen that there was, you could take a sabbatical or you could go on detail someplace. And I happened to see, we had just gotten this thing called a computer. And this, some of us had used it as footrests on the floor, but I saw this message flash across the screen, a detail at EPA on environmental justice. I didn't know what that was, but it's a detail. And so I finally got some information and went over and I interviewed for the position. They wanted a DOJ attorney to come over to help them with their environmental justice issues in the Office of Environmental Justice. DAAG at the time said, go. I didn't know if she thought I was more of a nuisance and she was just getting rid of me, or that she actually was interested in this thing called environmental justice. When I went, the second day that I was there, first day I read the executive order signed by President Clinton, Executive Order 12898, signed in February of 94. And the next day, I was with the director of the office to come with me. And we went to a meeting with, I was still learning the structure of EPA internally. Met with the chief of water division, Region 3, the OSFOR management. And they were quite upset because they had been working on, EPA had been working on an agreement on a dam in Virginia. And it was like 15 years they'd been working on this stuff. And it was like at the cost of at least $100 million. It was all going up the chain for approval, and this chief of water said, I'm not going to sign off on it. And they wanted to know why. And he said, well, it doesn't comport with the requirements of 12898. Now, people in headquarters, they'd never heard of this. They were really pissed. And how can you do this? And they turned to the director of the Office of Environmental Justice, who said, well, Mr. Pair from the Department of Justice will explain this to you. I mean, literally. I said, okay. The nexus of the problem was there was a tribe that was being impacted by this dam that was going to affect the fisheries of the tribe, the Mattaponi in Virginia. And they were, by the way, direct descendants of Pocahontas from and it was down to about 26 acres and very few people, but they were a recognized tribe. And this was going to severely impact their economics by putting dam. Not only that, it was going to be in breach of a treaty with King James and Virginia from 1617 or something, which said there's basically a no man's land between the tribe and the settlers. And this was going to be impact on that, all kinds of complications. And I said the tribe has not had an opportunity to participate in this, and it's required under the executive order. Mm-hmm. So we disbanded. I go back to my office, and the next day I get a call. It starts off with expletives. What the hell are you people doing? You have no business. Turns out it was a deputy chief of enforcement for Army Corps of Engineers. We had no business being involved in this stuff. So we set up a meeting with the Army Corps of Engineers and EPA. And there we are sitting there, and this deputy and his boss are sitting across the table from me. I've got all these EPA staffers and lawyers on my side of the table. In walks a one-star Army general, who was the district commander for Army Corps. He walks in the room, walks right around into the Army Corps people, comes to my side of the table, pulls up a chair, sits right next to me, and said, I have read the executive order. I have read there's a deal. I am not signing off on the deal because it is not compliant with 12898. And that, sir, was my introduction to environmental justice.
That seems like quite the introduction. It seems, I've not read the order recently, but the concept of reaching out to, I guess, marginalized groups who are impacted is a large part of that. And what did it say to you that very concept just seemed ridiculous to so many people at first blush?
Well, since you asked, it was ridiculous because they were wrong. And this gets into the whole issue of environmental racism, structural racism in this country. And I just finished a paper that I did for a journal. We'll see if it gets published, but tracing this all the way back to the founding of the country. But environmental justice goes hand in glove with slavery. When you look at what the resources in this country, you and I have the benefit of education, and we've got these marvelous computers and all, and people don't seem to understand that these things, whether it's jewelry, whether it's computers, they are manufactured with waste. Where does how is that waste disposed of? See, I go back when I've been my lectures to my students when I'm out lecturing. After World War II, the last nation standing was the United States and its manufacturing base. People wanted to buy from us, of course. Well, all of that, and real manufacturing base was in the north, and states in the south were just going, hey, we want to share in that. And the federal government gave some incentive to manufacturing in the south, and so many southern states invited northern manufacturers to come down, set up shop. They had great deals on taxes, cheap land, cheap labor, and industry responded. So about 60s, you had, there was real interest, late 50s, early 60s, in scientists, particularly government scientists, on pollution issues and problems, particularly when it comes to insecticides, and which were basically poisoning the land and the water. But it wasn't until Rachel Carson came along, and with her book, The Silent Spring, which was an indictment on the chemical industry, and it raised a furor. Well, she wasn't regarded as a real scientist anyway, but this thing really opened up a huge debate in this country. And it also was the stimulus for the concerns raised in the public wound up causing the Clean Water Act to be, they upgraded Rivers and Harbors Act. They upgraded the Clean Air Act, the Clean Act. Anything with clean in it, the feds were going to make into some kind of law. And then, of course, you had RCRA and CERCLA. And all of these things had the impact on society, basically saying, hey, you no longer can treat these waste products as external costs, particularly RCRA, which said you are responsible from cradle to grave. You make something, you make a computer, and you have toxic substances and waste from that computer, you are responsible for how that is disposed of, making sure it doesn't get out into the environment, much less affect people. And RCRA, of course, is a prospective statute looking at how we will take care of waste in the future, whereas Superfund, CERCLA, dealt with waste sites which were abandoned and prolific across the country. Who was going to pay for these things to be cleaned up? Nobody wanted to take that on. So the net was closing in on companies in general. So particularly in the South, in South Carolina, industry came, said to the legislature, hey, you invited us to come down here, benefits and all, that was great, but we used to be able to go in the back 40, dig a hole, pour our pollution in it, tap the soil down, voila, our waste problem was resolved. Now the government has got all these requirements. I've got 55-gallon drums of waste that I don't know what to do with. They're clogging up my parking spaces. I can't park my Cadillac there. I need some relief. So the South Carolina legislature said, don't worry about this. We're going to build a super waste facility out in the middle of nowhere, and nobody is going to be bothered by it. So they did in Warren County. Warren County happened to have some people there that apparently the legislature overlooked. But the facility was a big hole in the ground, unlined, with a fence around it, basically, and reached a depth that was only 7 feet above the water table. Now, much to their chagrin, as they found out, there were people living in Warren County. I forget the exact statistic, but I think it's like 80-some%, high 70s or low 80s, African American. And it was the poorest county in the state. Nobody in the legislature looked like anybody from Warren County. Nobody in Warren County had been consulted on this or been involved in a decision-making problem. And the residents were quite upset about it. And so what happened is when the day that they opened up that facility, residents were there to protest, and 500 of them lay down in front of these huge dump trucks that had contaminated soil, PCB contaminated soil. Most of it had come from midnight dumpers who had been convicted of dumping material during the night out in the back roads of South Carolina. And when they cleaned up these roads, they brought it here to this new site. And we're just going to put it in this big hole in the ground. Most of the 500 were arrested and put in jail. One of those who was arrested was Reverend Walter Fauntleroy, who was the representative for D.C. in the House of Representatives at the time. He was a delegate. And many of the residents' children joined in this, and they were put in jail. So I have a dramatic moment in my presentation where I say shades of Selma, Alabama. Most people don't realize how close to the civil rights movement almost went broke, because they ran out of bodies to be beaten from those freedom riders. They ran out of money for getting people out of jail, until the Children's March in the civil rights movement came in, and they packed those children into jails like sardines, as young as 12 and 10 years old. They used those water hoses on them, which could strip bark off of trees. They sick dogs on them. And when those photos went nationwide, that's what saved the movement. So, and I said dramatically, and here we are in 1982, the children have come to save their communities again. A little dramatic, I confess, but also true. So Walter Fauntleroy, when he got out of jail after his arrest, as a member of Congress, he's entitled to ask the Government Accounting Office to do reports and studies and investigations. And he asked the GAO to do a study of the relationship of where hazardous waste facilities were sited and the demographics of the communities, of the host communities in the southeast United States. Why the southeast United States? Because 1982, that's basically where black folks in this country lived. And Reverend Fauntleroy was black. He had an interest. The results of that study, 1982, from the Government Accounting Office. 3 out of 4 of these facilities were located in communities where the determining factors of where these would be sited was race and income. And the biggest determining factor by far was race. Income, low income, was a distant second. 3 out of 4. When I confront people about this, I said, suppose, I don't know where your parents are, but suppose you found that your parents were living next to one of these Superfund sites. Would you be concerned? Of course people would be concerned. How about your parents living near 2 of these? And then you hit them with 3 out of 4? Of course, this is just what? Accidental? So we shift over to 1987. You've probably heard of Charles Lee over at EPA. I call him the godfather of environmental justice in the federal government and in EPA. When he was back in 97, he was asked by the United Church of Christ, the Commission on Social Justice, to do a study, to take that GAO study of 1982, take it nationwide, not just in those 8 southeastern states. And along with Vernice Miller Travis, who was a renowned advocate of environmental justice, she was young, fresh out of school. And they got a grant, and they took the study nationwide. The results of that study, 3 out of 4 of these facilities were in, communities where race was the most determining factor by far. Low income was a second. All 50 states. So now we jump to 2007. Dr. Bob Bullard, very, very distinguished African-American scholar of environmental justice movement, gathered a very distinguished group of scholars who said, we've got the grants and the money now and the new computer technology. We should go back and take a look at that United Church of Christ study and make an evaluation of it. Okay, 20 years later, the results, not only 3 out of 4 of these facilities, same thing, race being the most important and income being a distant second. In fact, their results showed that they were even more intense. So you've got a 20-plus year history in this country of why is it always the dangerous, poisonous things go to poor people and people of color? Accident? We're looking for intentional discrimination. It's not even that. And when the 1987 study came out, the chair of the United Church of Christ Commission, he coined the phrase environmental racism, which is still used today. But environmental racism, all this kind of came about at the same time that it was after EPA was created by executive order in 1970. They were very slow to come to recognize environmental injustice, as it were. Finally they created the Office of Environmental Equity, and then finally the Office of Environmental Justice. And environmental justice became the coin of the realm because it sounded nicer than environmental racism. And quite frankly, it's when white stakeholders became more involved, because when I tell people basically, you need to understand this is not a black thing. This is not just about color. There are more poor whites in this country than there are people of color. Okay, people, really? And you started to see more of acceptance in the dialogue in environmental justice, environmental racism. So one last report to bring your attention to, and that is the National Law Journal. 1992 did a study. They took EPA's Superfund database, and they were looking at enforcement. The long and short of it is in communities of affluence, white communities, there was strong enforcement actions taken and cleanups and substantial fines on polluters. You want to guess in communities of color what it looked like?
I would assume less so, yeah.
Yeah, not good, not good. And these 4 documents, which I use in teaching my class, have not been contradicted. I mean, there are pot shots here and there. I mean, what kind of measurement did they use? Zip codes versus geographical designations, procedural things, but the core findings of these documents have never been refuted. So what does that say? We have a problem, okay? And it's tied directly to race, which goes directly back to slavery. Where did the slaves get, their chance? Where could they live? Where did people of color, particularly black populations, where could they get housing? There is a very important book, and it's so important, I should have it right here to tell you what it is, that I made my students buy this year. Color of Law. I pass that on to you. It's paperback. You can also get the audio. And it's quite clear, as he points out, the author said, there's de jure, and then there's de jure and de facto in terms of the law. And everybody says, that it's de facto. The racial problems we have today is a unfortunate result of our history of slavery and law, but it's not because of the law. And he sets forth an argument and substantiates the fact that racism has been a product and a design of the federal government as well as state governments in terms of redlining. You know about redlining. Mm-hmm. And not only that, but where the government gave out money, encouraged banks to give out money to create white communities, which were explicitly excluded blacks, less money for making black communities, in spite of the fact that, all badges of slavery were supposed to have been eradicated with the 13th Amendment, 14th Amendment, 5th Amendment, up to the present day. Communities designed with racial barriers. And, you think we have any Superfund sites in Georgetown? How about Beverly Hills or near the Magnificent Mile in Chicago? No. I wonder why. And I was telling this one class, I said, you know what? I got the mayor's home phone number on speed dial. Not this current mayor. I used to have it, but not she and I don't have it like that. I said, now, if you put a Superfund site or notice in the paper that I'm going to have a Superfund site 2 blocks, half a mile from my house, you don't think I'm going to get on the phone and say, do you remember that contribution I gave? And you get enough Quentin Pairs doing that with degrees after their name and money in their pocket. What do you think's going to happen? Now, you take Joe Sixpack, who lives out in the Southeast. Well, Southeast these days, who knows? So that's kind of a long way of saying that, that's how I got involved into environmental justice and the importance of it and why it's so misunderstood. It's now reflected with virus 19.
The coronavirus.
Thank you. It's just ripped the scab off of the inequities and inequalities of this country, and they directly line up with the accusations of environmental justice. Last point, the Executive Order 128 was not created by Bill Clinton or the federal government. It was written by community leaders, and they took that and they put legalese and bureaucraties around it, and it became Executive Order 128/98.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at www.americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.